Misrepresentation is becoming a very significant problem within Canada. There are many different circumstances that can entail misrepresentation, whether intentional or unintentional. If an applicant is trying to enter Canada and they find themselves inadmissible due to misrepresentation, the consequences can be detrimental. The applicant will then be banned from entering Canada, and the ban will be for a minimum of 5 years. Therefore, it is extremely important to note what misrepresentation means and the steps to avoid misrepresenting yourself. In this video, I will explain what misrepresentation means, how you can fight a misrepresentation allegation, and how misrepresentation can affect you in the future. Misrepresentation can be determined in many ways. The main similarity between all cases of misrepresentation is the inconsistent, inaccurate, or incomplete information given to Immigration Canada. In every case of misrepresentation, unfortunately, the principal applicant will be at fault. Although the misrepresented information may be given or omitted by the principal applicant or any of their family members or a legal representative, unfortunately, the principal applicant will still be at fault. Therefore, it is extremely important to review all information and documentation prior to submitting it to Immigration Canada, as the principal applicant will be the one suffering from the consequences if the information is incorrect. Some examples of cases of misrepresentation are omitting a family member from your application, providing documentation that is not genuine, failure to declare previous immigration applications, such as visas, refugee claims, etc., declaring false information with regards to your work or address history. If you have been allegedly misrepresenting yourself, do not fret, as Immigration Canada will give you the opportunity to respond and explain yourself with regards to their concerns. Thankfully, the Canadian government has implemented a process called Procedural fairness, which gives the applicant the opportunity to defend themselves when confronted with these allegations. There are certain factors that you must take into consideration when responding to Immigration Canada. They are extremely particular with timelines and will most often give you a specified time frame for your response. Therefore, you must be very diligent and respond with enough time just in case anything happens before the deadline. Additionally, Immigration Canada will inform you whether the response should be made in an interview or on paper. It is extremely important to analyze and recognize the specific requirements that they are asking of you, as these cases are extremely time sensitive and can lead to more severe consequences if they are not addressed. In many cases, Immigration Canada will request for you to bring the allegation to the Immigration Division for an admissibility hearing. This meeting will be in court, and Immigration Canada will give you a scheduled hearing. Ultimately, the decision will be made by the Immigration Division based on observing and analyzing the evidence and testimonies from both parties. There can be one of two outcomes. The first would be that the misrepresentation allegation is not well-founded, and the report would be ultimately dismissed. The second would be that the report of misrepresentation is well-founded, and the applicant will be issued a removal order. If you are issued a removal order, you will unfortunately be asked to leave Canada. There can ultimately be 3 different outcomes for a removal order. It can either be a departure order, an exclusion order, or a deportation order. A departure order requests that you leave Canada within 30 days of the removal order being issued, and you must inform Immigration Canada when you exit the country. However, if you fail to leave within 30 days or fail to advise Immigration Canada of your departure, then the departure order will consequently become a deportation order. An exclusion order requests that you leave Canada and must remain outside of Canada for a minimum of 12 months, and you must also inform Immigration Canada once you depart the country. Also, depending on your specific circumstance, you may be banned from entering Canada for a minimum of 5 years. Lastly, a deportation order requests that you leave Canada indefinitely and tell Immigration Canada once you depart the country. If you are requested to leave Canada on a deportation order, then you must apply for an authorization to return to Canada if you would like to re-enter Canada in the future. Therefore, it is essential that you look through and analyze all of the information and documentation that you provide to Immigration Canada before submitting any application. If you feel like you might be a victim of misrepresentation, we can definitely help you out. Here at Akrami & Associates, we have dealt with many immigration matters, and we have a lot of experience with misrepresentation. If you need any assistance, please feel free to contact us. With Akrami & Associates, there's always a way.